Hello and welcome to We the People. Child marriage has often been compared with child abuse. The law, you would imagine, is pretty unequivocal. When you look at the law, 18 is the age for women to get married, the legal age, and 21 for men. The age of sexual consent is now at 18 as well. Yet activists are concerned when they look at a spate of recent judgments coming from different courts that have actually upheld marriages that have taken place when the girl has been of a minor age. On We the People today, we ask whether the same age should be set for the age of consent and the age of marriage. And what about these ambiguities in the law? At the best of times, the law is not sufficient to deal with the prevalent practice of child marriages. But if the law itself is ambiguous, does that now not multiply the problem? Let me start with Aparna Bhatt, if I may. You have been working on this petition, actually arguing in the court that we need to universally define how we say who's a child and who's not. Yet we have found in more than one judgment now, whether in the case of Hindus or Muslims both, the courts have actually said that if the girl has gone voluntarily, and she has made that choice, then her being underage cannot be a reason to declare the marriage null and void. Why are you questioning this in the Supreme Court?
You see, when the context was about child marriage and how younger and younger children were getting married, and the courts were totally at sea to decide those marriages, whether they were legal or not legal, primarily because the personal laws were not supporting the secular law. We have today the prohibition of child marriages, 2006, which praised 18 for the girl and 21 for the boy as the age of marriage. Unfortunately, the exception to this act is the personal laws. So, till such time the personal laws are in conformity with this secular law, we will have an ambiguity forever.
And the personal laws happen to be both the Muslim Personal Law and the Hindu Marriage Act. So the media attention is focused only on the Muslim Personal Law, but actually the Hindu Marriage Act...
Hindu and Christians.
So none of the personal laws actually allow for age to be a criteria to declare a child marriage null and void.
Yes, so they are totally against the secular child marriages prohibition. On the other hand, one other critical point that we raised in the petition, when see both the National Commission of Women and the Delhi Commission of Women went to the Supreme Court, and the other critical was about criminal liability. You make the boy liable for criminal prosecution for rape as well as kidnapping and abduction. If I find that my young girl has gone away with her boyfriend, and I feel that she was not in a position to consent for marriage, and if she is underage, then I can file a complaint for kidnapping. If he gets married, the applicability of rape laws doesn't apply, but nevertheless kidnapping laws apply.
Tripti Tandon, it seems to be basically commonsensical that the law in India should have one definition of who's a child, and that there should be one definition. That's the argument that the petition in the Supreme Court is making.
The law as of today, and the primary law on children is the Juvenile Justice Act, and that very clearly states 18 as the age. So on that account, there's no problem. But I don't agree with the idea that for everything 18 has to be the cutoff age. So for instance, the decisions that you need to, the factors that you need to keep in mind in deciding whether to have sex are very different from the factors that you need to keep in mind when you're getting married.
So age of consent should not be connected to age of marriage?
Yes, I would suggest that.
But in this particular case, the problem really is that while a number of people may say that at 15, 16, 17, there are going to be young teenagers who are exploring their sexuality, and therefore, you know, that is why the age of sexual consent was so hotly debated. That is not quite the same thing as saying that at 16 or 17 uphold their right to be married. And isn't that the problem, that there is an ambiguity in all these personal laws that allows for that?
More important than the age, and of course the law requires a cutoff to be made, it's what is the principle that we are concerned with, and I think that is the autonomy and the consent of the girl and the woman. So
but
that's
can she make an informed choice at 16 and 17?
No, that's precisely why we have this problem. The reason why we don't want child marriage is because that marriage stifles the girl's ability to develop herself, make an autonomous choice. At the same time, when young girls, 16, 17, do make that choice and get married to their boyfriend or whoever it is, we again clamp down using the criminal law machinery to, you know, charge.
So you're saying it should be left to the girl?
The principle is important, and I think
are you saying the principle is it should be left to the girl?
I would say that the girl's autonomy must be irrespective of what the age we may decide.
Now, Javed Akhtar, this is a very complicated sort of situation, because at one level we are saying that you can't get married till you're 18 if you're a girl, and 21 if you're a man. I'm not actually, I never understood why it shouldn't be the same age. The other laws is that if you have sex below the age of 18, then somehow you're breaking the law. Now, when we hear about the autonomy of a woman or the right for her to make a choice, I mean, I remember myself at 16 or 17, even if I thought I wanted to get married to somebody, or even if I thought I wanted to have sex with somebody, I could not have been making an adult choice. That is how I remember my teen years. So I find this very complicated to say that you respect the autonomy of a 16-year-old or a 17-year-old, because we were effectively children.
I think, Barkha, we are confusing two topics which have very little to do with each other.
Which is sex and
Not
marriage?
That they are
Which is sex and marriage?
Yes. First of all, if we say that it should be the girl's choice, we are saying that girls have choices in this society, which is not true. More often than not, they are compelled to marry at a very young age.
Or socialized that way, or brought up that way. Yeah.
By stopping them, you are giving them protection, minimum protection.
Yes.
Personally, if you ask me, 18 is also too young an age for getting married. As a matter of fact,
I agree.
It should also be 21 for the girls also.
Yeah.
Point one. As far as the sex out of marriage, before marriage, premarital, whatever is concerned, it has nothing to do with personal laws, because no personal law allows sex outside of marriage bond. So it is not their topic. We should not discuss it with them. You know, in most of the cases, they will suggest capital punishment for that. Now, 16 is definitely the right age, because at 16 a girl knows what she is doing. She is not mature enough to get into an institution like marriage, but she is mature enough to know about what she is doing and what is sex. It was 16 from 83 to 2012, and nothing happened. I think there was no revolution. Society did not get into a chaos. Girls did not become haywire, mad, crazy.